I'll try to be as brief as possible and pointed. Well, as my first submission is just touched upon briefly by my learned friend, but I want to cite a judgment on that. And that is this, fellows. You have a power given to the Election Commission. Let me tell you the structure of the argument of this first point. This is the first point, fellows. You have a superintendent's direction, etc. power in 324. We all know the Election Commission has that power. And then you have a power given in 327 to Parliament. It's a little important constitution. Parliament to make laws. So just see the language, just see the Constitution, 324 and 327. Kindly give the Constitution. So you just be ready with the case law. I'm using that for them, copies for them. Yes. So I'm not going to read it, but just see the structure. My lord is familiar. Superintendent, direction and control of elections. Now, suppose it was untrammeled by a parliamentary law under 327. So it's totally unoccupied field. Your lordship would have nitty-gritty created by all kinds of enumeration forms, etc. I hope I'm clear with this. Now, 327, see the first line now? Subject to provisions of this constitution, Parliament may from time to time by law make provisions with respect to all matters relating to or in connection with. Now, Parliament goes ahead and does make such law, the so-called ROPA, R-O-P-A. When it makes such law, it says that the only forms you can use are 4, 6, 7. I'll go to the nitty-gritty in a minute. Not your own new form, which is not supported or sanctioned by parliamentary law. That's my first point. And you cannot allow your supposed, according to me, non-existent executive power to operate in the interstices where parliamentary law exists. So it's an important problem because the whole thing here, it is common ground that some of the forms and the queries they are asking is not in the Act. Your Lordship has 3 crucial anchor forms in the Act, 4, 6 and 7. What we are asked now is admittedly divorce that. Now the attempt is to trace the power to my plenary power under 324. Now remember, you have occupied the field by parliamentary law. Now 2 arguments can come. Parliamentary law does not prohibit me, that is Election Commission, from doing X, Y, Z. Or a misreading of the first opening 3 words, subject to the provision of this constitution, means subject to 324 also. Both have happily been debunked by my lords in an important judgment. Once Parliament occupies and you have to follow, otherwise you are rendering nugatory. Parliament decides, chooses to have only 4, 6 and 7. It chooses not to have 4A, 6A and 7. Now you can't say that because Parliament does not have 4A, 6A and 7A, therefore I will act in the interstices on my executive power. That's the judgment. Please turn to that. Give the judgment. Page 42 of the written submission. I also have a written submission. Give it. But I have given my written submissions. I will hardly use 5 pages of this. It's a very bulky one. Forget it, Maras. Don't go into it. But next to that, Maras, is also this judgment. Yeah, I think. This judgment is, Maras, Chose versus Pillai, 1984 to SCC 656. Because this is a fundamental importance principle because the whole case is about the EC purporting to act divorce specific statutory power. We have no problem if you act on 4 and 6 and 7. Now I am attacking the root of the non-existence of any other power altogether. We are now not on individual grievances and all this, but this is also serious, but we are on the legal principles. So come to this judgment, it's a 3 learned judge bench. In 84 to SCC 656, which is page what? 42. Page 42 of my written submissions. We have annexed it. Come to the relevant paras, keep it flat. Keep it flat. Well, let's come to... No. 7. I'm interested in later paragraph to start from 7. The real paras are 23 and 24, but just start with 7 just so that your lordship gets the context. May I read 7, Manas? 22 and 23. Give me 2, but don't keep jumping. Give me 22, which one? Just. Don't keep saying kabhi 22, 23, 23. Just give me 2 paras. Does my lord have Manas para 7?
Yes, yes.
Another golden rule laid down by this court on the interpretation of statutes is that we should so interpret the language of a statute as to suppress the mischief and advance the object. It is true that 324 does authorize the Commission to exercise powers of superintendence, direction and control of preparation of electoral rolls and the conduct of elections to Parliament and state legislatures. But then the article has to be read harmoniously with the articles that follow and the powers that are, mark the word, with the articles that follow, that is 327, Malas. It follows 324. And the powers that are given to the legislature under entry 72 and of list, union list, and entry 37 of state list. The Commission, in the garb of passing orders for regulating the conduct of elections, cannot take upon itself the purely legislative activity which has been reserved under the scheme of the Constitution only to Parliament and the state legislatures. By no standards can it be said that the Commission is a third chamber in the legislative process within the scheme of the Constitution. Merely being a creature of the Constitution will not give it plenary and absolute power to legislate as it likes without reference to the law enacted by the legislatures. Now come to 22. And Manoj, I repeat, they are actually in the guise of this doing substantive changes, which is legislation. They may camouflage it. Oh, it's nothing, it's just a procedural rule. All these 75 years or all these 22 years, we have not had the requirement that you fill up a form first and then I will presumptively retain you on the list or remove you. This is substantive change, which can only be done by a legislature. 22. Para 22. Further, such an absolute and uncanalized power given to the Commission without providing any guidelines would itself destroy the basic structure of the rule of law. It is manifest that such a disastrous consequence could never have been contemplated by the Constitution makers, for such an interpretation as suggested by the counsel for the respondent would be far from attaining the goal of purity and sanctity of the electoral process. Hence, we must construe 324 to 329 as an integral part of the same scheme, collaborating rather than colliding with one another. A perusal of 324 to 329 would reveal that the legislative powers in respect to matters related to Parliament or the state legislature vest in Parliament and in no other body. The Commission would come into the picture only if no provision has been made by Parliament in regard to the elections to the Parliament or state legislatures. Furthermore, the power under 324 relating to superintendence, direction and control actually vesting or merely all the executive powers and not the legislative powers. In other words, the legislative power of Parliament or of the legislature of a state being made subject to 324. So this answers the query that somebody argues that subject to means subject to also 324. No. Subject to only means that no law made by Parliament under 327 or by state legislature can take away or deprive the Commission of the executive power in regard to matters entrusted to it, superintendence, direction and control. The right to file election petition, forget that. Come to 25. The summary is very good, Malas. The summary is very good. It puts it a focus. To sum up, when there is no parliamentary legislation or rule made under the said legislation, the Commission is free to pass any orders in respect to the conduct of elections. Where there is an act and express rules made thereunder, the Lordship will mark ROPA and the rules thereunder. It is not open to the Commission to override the act or the rules and pass orders in direct disobedience to the mandate contained in the act or the rules. In other words, the powers of the Commission are meant to supplement rather than supplant the law, both statute and rules, in the matter of superintendence. Where the act or the rules are silent, the Commission has no doubt plenary powers. And then Malas particular direction. Now Malas developing this a little more, it is common ground that we have 4, 6 and 7. What is 4, Malas? Form 4. Statutory form prescribed, which is a form for a de novo rule or a de novo Malas change in the role, which is form 4. And form 6 is for inclusion. And 7 is if somebody outsider objects and I challenge him and I fight it out and I retain myself. Now, so we are not concerned. I'm not challenging the validity of these rules. That's not this kind of a matrix. I ask myself a question. In June 2025, the form which was issued, simple question, where is it found in the rules made by the ROPA? In June 2025, you had a form. Forget that your lordship gave safeguards. I'm arguing legal points for this. That form says 11, 12 or whatever documents. Does such a form exist anywhere? Clearly it does not. That form could be prescribed only by and only by delegated legislation under the Act through parliamentary law in the form of rules. 324 does not plug that gap. So that's the first point. The second point is related, of course, all that you by that form made a rule also that unless and including inter alia for a certain date proving both your parents' certificates, for a later date only one parent, and for other date only yourself. The second question I am asking myself, where does any parliamentary law or rule permit that? You are asking for a birth certificate cumulatively of two parents, one parent, or yourself. And you have said that it is basically for verification of what? It is not for verification of a photograph. It is not for verification of the fact that I am standing in front of you. That's a different verification. I have no problem with that verification. If I am a dead man and he tries to become an imposter for me, that's a different verification. This is a verification for deciding whether I am a citizen or not. This is the second aspect. The third aspect, of course, is that the scheme of the Act and the rules envisaged an individuated exercise, not a blanket en masse exercise. This is the real problem. Nobody denies to the Election Commission an individuated case power. If I bring material to show that my learned friend here is clearly not a citizen of India, nobody is saying it will be brushed under the carpet. But that's a bilateral or a trilateral individuated exercise. This is a very important conceptual issue. Never before in the history of India, and not under the ROPA, not under the rules, are you allowed a en masse right at one state alone for crores. And next state and next state and next state will be crores plus crores plus crores. Where is the power? So there is a slight nuance here. Your lordship is being told by the other side to create a bugbear of a fear that, look, if you don't have the power, how will you decide citizenship? But then what is Rule 7 for, and what is Lal Baba Hussain for? Let us look at those two things. Look at Rule 7. The Act, to the extent it wanted to, took care of it. Now you want to expand the Act, that's not your business. Come to Rule 7. Sorry, rules. No, Form 7. Form 7, I'm sorry. Where is it? Where is it? Form 7. So I'm sorry, I said Rule 6. It's Form 6. Form 7. Form 7. Voter application form for objection for proposed inclusion, deletion of name in existing. So an individual verification to assuage your lordship's doubts and to have a mass of this imagined influx of non-citizens marauding over India and invading India, which of course is a figment of imagination, but let's assume there are many of them. The many of them have to come one by one under this. So I will file against her, she will she will contest it and some third party will decide it. I will file against him, he will contest it and some third party will decide it. You have a provision, Rule 7. Form 7. Is it not going beyond 327 to supplant this by a massification exercise? That's the third point. This massification en masse is a very important point. That was a power never envisaged to the Election Commission, which is now trying to locate it in 324. Which is why I cited Joseph's case and this Jose case and this 327. Because if you assume to yourself an en masse power, then Manoj, you can actually, if you had the wherewithal and the lever, you could do the entire All India at one time. All India SIR would happen. So how many in All India population of, let's say, voting population of 90 crores? There will be 90 crore form 7 objections filed and contested. Well, this is serious. This is a lack of jurisdiction I'm arguing. Your lordship's curing and plugging a hole here and there will not matter. This is a lack of jurisdiction. You have illusions of grandeur, Mr. Election Commissioner.
Going by your argument, Dr. Singh,
Yes.
the commission will have never a power of SIR.
Power of?
Power of conducting the special intensive survey.
No, Malas. I'm coming to that. No, I will not go that far. You will have a power of doing a revision of roles, which is not presumptively saying that you are at the moment assumed not to be on the roll, you show you're on the route. And secondly, for the whole country as a whole or whole state as a whole.
It's not a routine or ordinary updating of the electoral roll.
Yes.
It's a special survey, right? Unless the rule or the statute itself contemplates a procedure to be followed, any process which should be fair enough and transparent, that can be adopted by commission.
It can't be.
Because if there is no power of survey matter ends,
no, there is no power.
Then rules will not create that power.
I must answer my lords frontally. My problem is this case has gone on for 6 months and your lordship has done a lot of effort and work to try and plug a healing touch, Malas. It's genuine.
Yes, sir.
But in that we have forgotten the law. That's why I'm saying, Malas. Assume your lordship gives all the healing touches. If there is no power, there is no power. Now my lord put a question to me. You can't say there is no power of SIR. I am saying there is no power of SIR of this kind. I'm saying so. I'll make it good in 2 minutes first. An SIR is a revision of roles on an individuated or a bilateral or a small group method. And it is limited to a constituency or a part of the constituency. There is no power of en masse. That's why I started with 324. Much more important is 327. Well, 327 recognized that Parliament decides the limits to which you will go. Parliament decided the limit. It said, just now turn to Rule 21, bracket 3. Now you can read it to me in the whole of India is a constituency. That will be distorting of the whole provision. Well. The whole of India is 565 constituencies, therefore it is also one constituency.
21 of?
Section of the Act.
Yes, preparation and
ROPA, which is the Act under 327. So, my lordship will read the connectivity. 324 read with 327. 327, the judgment of Jose. And under 327, the operative law is this one, ROPA. That's the 327 law, which the Constitution envisaged. Not Parliament alone, simpliciter.
Very opening line of 21.
Yes, let's read one.
The
electoral roll for each constituency,
not of a constituency.
No. This is the preparation of the roll in the beginning. This is the original preparation of the law.
Yes.
We have passed 75 years of Indian democracy with those rolls existing.
Or any constituency.
The electoral roll for each will be prepared by reference and shall come upon final. Now, may I read first what was my focus on 21.3? That's a non-obstant. It's a non-obstant. Notwithstanding anything contained in 2, the Election Commission may at any time, for reasons to be recorded, this is where your lordship's word comes, but it's the only place it comes, virtually, maybe there's one more place for this. Direct a special revision of the electoral roll for any constituency or part of a constituency in such manner as it may think fit. Well, this can't be read to distort it to mean that any constituency or part means the whole of the 535 constituencies of Parliament or the whole of the 1,000 assembly.
If the regions to be recorded are common to the all constituency of a state, can the commission still say that by virtue of this language of any constituency or part thereof, I will do only in part? Will it not be discriminatory?
No,
and will it not attribute an action of pick and choose on the part of the commission?
Let us answer the question contextually. I don't want to give a general answer. 2 facts are peculiar to this case. 2 facts. And does the law apply to those 2 facts is my question to myself.
One argument can be, one argument can be, one, that there is no region at all recorded. 2, the region recorded is non-existent. and therefore the very foundation of the power is not there.
Well, my part.
And it will apply pan state.
No, my problem is those arguments may be there. They are the how arguments. I'm on the if argument, Balus. And I'm not prepared to give up the if argument. Because if your lordship finds them not to have jurisdiction on the if argument, how will never be reached? Of course, it is important that if you have the power, how you exercise it has to have all those criteria which my Lord the Chief Justice is saying. But you don't have the if. Why don't you have the if? Let me answer that. There are two peculiarities in this whole exercise. Radical peculiarities. One, it is always minimum state-wise. And the states we've started off are the most populous states of India. Bihar and now West Bengal. There are hardly more populous states except Uttar Pradesh, Maharashtra and a few others. Two, there is no individuation of any kind, any constituency or part of a constituency. Not an attempt. Unique case. What my Lord is thinking is, well, they are trying to fit a square peg into a round hole. This was the where it was to be. They are fitting something totally different into this. Third peculiarity. Third peculiarity is that you do not follow the form made under this verse, under this 21, which is form 7 inter alia, to have an individual. I can understand you have 1,000 individual exercise. Let us assume that in a constituency, your lordship have 1,000 objections. You don't follow that. Form 7 is not followed. And fourth, this is the fourth thing. This is four peculiarity, not two. Fourth peculiarity. This is accompanied by a virtually clear declaration that the purpose of this SIR, which I say is no SIR at all, is to first say that we have an old list. This is the old list. All of you here, by my quirk of the pen, are presumptively declared to be here tentatively. Or, like a Trishanku, you are there at my largest, till I confirm your residence on my list. Well, let's be very blunt. Jurisdiction is decided by bluntness. These are, if any of these four are factually incorrect, your lordship may correct me. The fourth is the declaration of the EC, maybe not in my blunt words, that all of you people in the whole of the Bihar who are on this list are there, but I have declared you presumptively as temporary. I will confirm you in 3 months. Give me 11 documents. Now there is 12 and 13. And I will confirm you. If I don't confirm you, goodbye, sorry, off this list. This cannot be the special revision remotely or distortedly contemplated in 21.3. And that's a...
So those who were in 2003, they were not required. They were already, they continued
Right.
to be confirmed.
Right. So, no, but the role exists in 2025 also. Your lordship is right. That's part of the discriminatory approach. No, that's an argument in my favor. I'm going to raise it separately. There is a role in 25 is common ground. 24, let's look at 24. There is a role in 24 January, which is this role. There was a role in 2003, which is this role. Now leave aside 2003. You are saying that everybody between these two roles who are on this role, 25 subsumes, because 25 role will include 2003 and whatever else has happened in between. So all that is said is this 25 role, I am declaring you presumptively to be my temporary guest. When I check on you, and I will check only by the citizenship test of those 11 documents, which itself are not in the form, which itself are not in the statutory form, which itself are not part of the section or the rules. Then, having presumptively put you like some kind of a temporary guest, I will then, of course, maybe confirm you, maybe not confirm you. Now, all that is detailing. My question to myself is, where is your power to do this? The power starts with 324, which was the only power they relied upon. 324 is trumped. That's a dangerous word to use nowadays. It's trumped by the law made by Parliament under 327. The law made by Parliament under 327 specifies in 21.3, in 4, in 6 and in 7 how far you can go. It nowhere contemplates this presumptive approach that pick up the role here. And till such time as you prove. So, but that's the long and short of the if question.
But then going by this argument, we have to accept that constitutional power can be limited or restricted by through a legislative means.
Where the Constitution itself permits it. That's why they put 327. My lord is right. But for 327, that would not occur. That's precisely why 327 was enacted, and that's the meaning of this para 25 of this judgment. Now turn to para 25 again of the judgment. Para 25 actually puts it very pithily. Justice Fazal Ali Malik says, no, it is a judgment. No, this same judgment. Jose. Same thing here. Whereas your lordship is absolutely right. The whole purpose of enacting 327 was to allow Parliament to occupy the field which will do the nitty-gritty of electoral law.
That's part 320. Dr. Singh, let's not argue something which ultimately damages the very constitutionalism. 327 is a power, is an enabling power how to give effect to the constitutional scheme. Today, if you 327 you give such a vast power, then you are also probably arguing something against the basic structure doctrine.
No. 327 is not a power to overturn the constitution. This is answered by a lot.
327, if 327 lawmaking power can curtail or restrict or define the contours of 324.
No. Now, this is exactly what is answered. Just give me 2 minutes. May I answer? This is a very important question. Your lordship's query is first answered by para 25 of the judgment. Then I'll come to the other paras. Just turn 20. No. First 25. Come to 25 first. Then I'll come to the other paras. Directly answer. Well, Parliament is also custodian of our rights, not the Election Commission. If at all, Parliament is higher than the Election Commission.
That's right. But
Parliament chose to go so far and no further. Who are you to go further?
Let us see.
They may be wrong, they are Parliament. Now kindly come to 25. Kindly come to 25. To sum up, therefore, the legal and constitutional position is as follows. May I read this story? It's very important. Page 55 of this written submission. Yeah, please do. गर्म पानी का बोलो और बोलना कि 4 बजे के बाद में आ जाऊंगा तो जाते 4 बजे
There is only one instance of one constituency in UP where this kind of special intensive revision was done. That was done in 2001. Only one, that was Thakur Dwara, where the old
Wait, please, Malad. Now, Malad, your lordship knows, to take a loose, not exactly Malad's direct example, but it's an interesting analogy. Whereas in our parliament, I happen to be also in the privileges committee. So we went into these details. The similar provision is there till such time as parliament by law. Take out the article. Take out the article. Now parliament deliberately chose not to make. Because the idea was that the flexibility in the joints of parliamentarians to act in a certain way. So they said that, look, stands codified as it was in England in a certain date, but nobody knows what they were. Parliament is entitled to make law. But since no parliamentary law has actually been born, saying clause A, clause B, privilege means hitting a parliamentarian, obstructing him, no listing is done. That means from case to case, Parliament decides this is privilege or not. Sometimes they do it wrong, sometimes they do it right.
That's right.
But the moment Parliament, the whole debate that it should not do it because you will confine the flexibility of parliamentarians. There's another debate that it's too uncertain. After that Keshav Singh, they said it's too uncertain, you must control it. You can't go amok.
Understandable. Part 327 power is just...
It confines, cribs and circumscribes the power of the EC to act, dehors that on the same subject.
To act in conformity with the constitutional scheme. Tomorrow the parliament says that you take away the particular right of the franchise. Can you?
No, on the contrary, absolutely not. On the contrary, this judgment says they don't collide. They harmoniously operate.
Harmonious, exactly. So the law under 327 will be in furtherance of
Further.
the cause of 324 to be achieved.
Absolutely.
There can't.
Absolutely. Now, Parliament decided, so that's why I listed 4 features, and there's a 5th feature which I'll be listing just now. Parliament decided to go so far and no further on 4 features. Call my features A, B, C, D. I'll add an E in a moment. They decided the boundary of expanding A, B, C, D till here. Namely, we will not ask beyond 4. If there are individuated objections, we will invite objections from him and he will decide under Form 7. And if the Election Commission wants, we will allow him to do it constituency-wise or part of a constituency on a special revision, is what the word used in 21(3) is. Parliament did not intend to vest in a persona designata, the EC. Well, Parliament cannot vest it in somebody else. They are also bound by the Constitution. Parliament has to give it only to the EC. They decided not to vest in the EC the power of what I call en masse decision. That power is for the first time being exercised in these numbers in this manner. That takes away what? That comes to the 5th aspect. It takes away individual adjudication, individual application of mind, individual decision making. There is no way in which a massification, Malas, by first creating a rule that you are presumptively there as a temporary guest, and unless you prove, all those arguments will come in, burden of proof is on you, etc., the 3 documentations. The 5th feature, Malas, flows from the query from the Honorable Chief Justice. Actually, the 5th feature would be, Malas, a invidious discriminatory classification between 2003 people and post-2003 people. In essential treatment, 2003 people are not touched. I can understand that they're given lesser regulatory scrutiny. They're not given lesser regulatory, they are excluded. 2003 to 225, during which in each state, this very election commission has done innumerable revisions. Summary, special, comprehensive, each state 4, 5. We have crossed 23 years, 22 years. During that time, having done so many revisions, you create a new class to which you subject 3 sub-classifications of 2 parents, 1 parent and yourself. And the other class you exclude altogether. So that will actually lead to a further argument of Article 14, sub-classification, which is not valid. Well, no rational nexus can be indicated between those who are there or not, unless, yes, there can be one, that you have become a citizenship tribunal. Be frank enough to admit it, no problem. Then we'll deal with it. Here you are, Malas, trying to masquerade either as a sheep in wolf's clothing or a wolf in sheep's clothing. I don't know which one, Malas. But you are trying to say, I'm only the EC. I'm not a citizenship tribunal. If you are only the EC, in which case, Malas, this classification between 2003 and 2025 can't be a valid classification. In fact, Malas, maybe even the classification of asking me alone, in this category, my 1 parent, and in that category, my both parents, that may not be a valid classification also. Where does the law permit, Malas? Where has the law? Malas, this is a very major thing. I lose my vote. Well, I said jocularly in the first day, Lordship may have forgotten, that if many of us in this court, including judges, were asked to produce both their parents' birth certificate, I don't know how many advocates or how many judges would have their parents, both their parents. Now that's all right. That's, you can throw it in the dustbin. It doesn't matter. In most cases, you can get an Aadhaar card or a ration card. But where your vote is being lost on that, it's a major consequence. So there are 2 further invidious sub-classifications which may actually hit 14 more, not less. One is 2003 versus 25. And the other is between 2003 and 25, 3 sub-classifications, 2 parents, 1 parent and alone. Now, Malas, my submission is this. Now, just read 25. This part of harmonious is taken care of by para 25. This is a very important point. 3 learned judges have stood the test of time, Malas. This judgment is, Malas, now almost 50 years old. It's not 50, less than 50, but nearing that. Now just come to, Malas, para 25.
Yes.
At page 55.
Yes, to sum up therefore.
Yes. This is a very good and a very pointed summary. So A, we are not concerned with, Malas. But it's an important contrast. That's the privileges contrast I gave you, Lordships. A is when there is no parliamentary legislation or rule made under and pass orders in direct disobedience to the mandate contained. In other words, the powers of the commission are meant to supplement rather than supplant the law in the matter of superintendence, direction and control, and they always say statute and rules. Now, of course, your Lordship will decide whether they are doing on the facts of this case. But the principle is clear. The boss, the parliamentary law is the boss. This para undoubtedly says that, Balas. Whether on the facts of case 1, your Lordship find it violated or not, action by the Commission is submitted to the government for approval as required. It is not open to the Commission to go ahead with the implementation of it its own sweet will if the approval of the government is not given. Right, Wallace? Now, I will meet it frontally. I'll try and take the bull by the horns. According to me, the best argument of the other side would be that please read clause C. I'm putting the point against me and answering it. Directly, there is no provision saying thou shalt not do a Bihar SIR, saying thou shalt not do a Bihar SIR or the whole of SIR or the whole of SIR, or that you cannot say all of you are presumptively on it and then you will go away unless I confirm you. There is no direct occupied field by the legislation. That's the highest argument you can put it was against me. Well, is there a fair and a valid argument? I ask myself. This parliamentary law is purporting, Lordship knows this is a very important constitutional issue. The Lordship has done enough cases of conflict of laws, but repugnancy. Your Lordship has a very straight principle. Repugnancy doesn't mean that the two acts actually occupy. The Parliamentary Act must evince an intention to occupy. That's the test. Your Lordship knows. In repugnancy law, under 254, arises only in list 3. It is not that this law of Parliament occupies directly the field which the state law is trying to occupy. The law is very clear. Cite that, Constitution bench judgment said. If parliamentary law evinces an intent to occupy, then the state can't come there. My question to myself is, if the Parliament provided 4, 6, 7 and 21(3), let's look at 4 provisions. Does it not clearly evince an intent to say the exact opposite of those 4 features? 1, when you have a problem of an individual person, get an objection and decide it, Form 7. When you have a problem with the whole constituency, deal with it. Maybe 10 constituencies, deal with under 21(3). Then go under 6. Now, Mills, this is obvious. I mean, you can use all the kinds of principles, expressio unius. When I specifically say something, impliedly everything connected to it, I'm excluding, Mills. Parliamentary intent is clearly being subverted under 327 by having this kind of, that's why for 75 years nobody did it, Mills. You are now told state-wise we will do it. State 1, state 2, state 3, en masse, non-individuated. Not bilateral, not trilateral, not even 100 applications together. In which case, Mills, this law which is there, Mills, from 1950, which is almost 75 years plus now, could not have intended to do it. Now the answer is not that the law does not specifically deal with that subcategory which you are arguing, Mr. Singhvi. The law clearly intends to, evinces an intent to, and the scope is to cover that area. And your Lordship is really being asked to make a mockery of the law by the Election Commission if they say that, look, ignore this law, I am going on a parallel path with the law. That can be the highest argument against me.
We have the power to assess it.
Now, Mills, and Mills, sometimes, when your mind is thinking in a particular way, then the cat is out of the bag, even though you are giving a fig leaf of a camouflage. Later on, arguments have been camouflaged that we are not. But they say in the counter affidavit, Mills, clearly, that an assessment of citizenship under 326 is what we are doing. They say so. Now, Mills, the ROPA, to be fair, is not excluding an assessment of citizenship, but only as per Rule 7, Form 7. Not what they are saying. This is what was given expressly to 2 tribunals, to 2 separate laws actually, not tribunals, separate laws. One is a separate law which creates a tribunal called Foreigners Tribunal, especially for the Northeast. The second is a separate law, which is also parliamentary law, Citizenship Act. Now just see for a minute their counter, para 86, page 56, so I can read it slowly. Without taking your Lordship, that will waste time. Para 86, page 56 of the counter of the EC dated Common Counter dated 19/7/25, filed on 21/7/25. There's a common counter. No. Why do you want to say before 4 o'clock? What is the point of this? Now this was at the level of Form 7, nobody has a problem.
Page.
Page was 56, rule, para 86, page 56. I have no problem with this sentence at the level of Form 7. I have all problems at the level of the whole state.
Yes, para 86.
It is thus submitted that the ECI is vested with the power to scrutinize whether a proposed elector fulfills the criteria for being registered as a voter in the electoral roll. A elector, which includes inter alia and assessment of citizenship as per 326. Such scrutiny is constitutionally mandated and crystallized by virtue of RP Act 1950. The power flows directly from 324 and 326. Right, Mullahs? Now, please point out to me, I will ask them, Mullahs, where this power flows other than 7. Turn to 7 now, Form 7. Is there anywhere else which we have missed out where this power flows from, Mullahs? Anywhere else? Any other question?
No.
Section 21, Dr. Singh.
I'm sorry.
Section 21 also check. Section 21. Section 21.
Yes.
of,
So that's the next thing, Mullahs. First, 21, Mullahs.
Because 7 is on an application
Yes.
and 21 includes on his own
So,
motion.
Mullahs, the 20,
Momoto.
so 21. I'm sorry, I missed out.
21 will not, when it invoked on its own motion, an application under 7.
Correct. So 21, what is what I started off earlier. Now come
Yes.
back first to the non-obstandent 21(3). Let's see the provisor also.
Of 21.
Yes.
Yes.
Now, Willis, this is the one subclause of 21 which is non-obstant for a reason. The statute is not very non-obstant for nothing. Ultimately, Willis, to some extent, your lordship will have to interpret constituency or part of constituency. If it means the whole, then it's right.
Then it's right.
Yes.
If any,
Notwithstanding anything
if
contained.
any Dr. Singhvi is multiple,
Now, that is where I have a problem. Let me just read it. The Election Commission may at any time, for reasons to be recorded, direct a special revision of the electoral roll for any constituency. Any doesn't mean all. Any means one out of many constituencies. Whereas any always means a pointed constituency.
So suppose
Your lordship is being told any means also all. I understand. I understand, Willis.
not only that, the election commission will compulsorily be required to undergo this process for every constituency if the reason to be recorded for a particular constituency is subsisting and in existence in other constituency also.
So, Malas, if they were to go
Take
constituency,
for
wise,
example,
you can do it.
let us take one example, not necessarily that will be ground.
Yeah.
For example, commission say that in particular state, there are large scale dead persons who are voters.
Correct.
And those dead persons are in every constituency. Now, how to say for commission that in 50 constituencies I will exclude the dead, but in others I will not touch?
So, Malas, I'll tell you, very well. They will not do what they've done now. At all. They will do the following. They'll do the following. I must
What
answer
they
my
have
lord.
done, we'll examine later. We are
Answer my lord
on
candidly.
21 only.
Correct. I must answer my lord candidly. First step one, and they've done it. I'm going to give you also the orders where they've done it. This is a new brainchild and a new brainwave. Earlier it has happened.
No,
They
we are
will
not,
first
we are
record-
not right now on their action. We are on interpretation of 21.
The lordship will continue on some.
and also examine Dr. Singhvi 22.
So 21, 22, I marked it both.
Yes,
I was right.
because that is where on its
Correct,
own
correct.
motion is there. I was
See,
making a mistake.
interpretation of 21, this proviso
Yes.
can be altogether different their action can still be, assuming 21 has very vast power.
Well,
But exercise of power may be wrong.
I'll be dealing with, no, exercise is one part, my lord.
As of now, we don't want to test 21 on the basis of what the action they have done.
My answer is going to
We
be,
want to independently interpret and understand 20.
deal with it. They have never dealt with special revision in the sense of the Bihar or the other, never ever. I'll deal with that. Let's not waste our time.
My lord,